June 15, 2023, this is my dad's birthday, except for that he's in heaven with Jesus Christ because he believed the gospel. He knew Jesus. He knew that Jesus died for his sins, was buried, and 3 days later he bodily rose from the grave. And so Dad is in heaven. Happy birthday to Dad. I want to talk to you about how common law is going to overcome globalism. And I want to use a very specific situation that is close to me. I want to talk about Rogers County, Oklahoma. And I want to talk about how globalists have a plan to move into rural communities, to collectivize agricultural land, and to do it through a corporatist, communistic, capitalistic venture. These godless commies are deceptive, they are incredibly shrewd, and the way that they're going about the destruction and the collectivization of our property and undermining of our liberty is incredibly calculated. So I'd like to just today walk you through something that I did today. I just served my county commissioners not but an hour ago on June 15, 10 o'clock. And so now all three county commissioners have the notice that I gave them. But before walking through line by line so that you can understand the law and what the common law is and what your rights are and how to do petitions to manage the affairs of our government, I want to give a understanding of the battle space. And so right now I want to go to, if we can, I want to go to this on screen. And this is the Biden-Harris administration launches a $1 billion America the Beautiful challenge to support and accelerate locally led conservation projects. This is from April of 2022, if you can see. Now, you can go through here and you can read all this kind of stuff, but they're giving $440 million of federal resources to this public-private grant program. This public-private grant program. What they're effectively doing is they're taking the government, and the government is going to contract with third-party entities. And those third-party entities are not subjected to the Constitution, though they are now in contract with the government. So you take globalists, and globalists are going to contract with your government, and whenever your government is in contract with third-party entities, this is how the large corporations are going to get smart cities. It's how they're going to get different land usages. This is how they're going to do what's called name placing, where they will designate your area, whatever region you're in, to have its own tourism attractions. See, the globalists want to take away your ability to produce. They want to take away your industry. They want to take away manufacturing. And that's because simultaneously depriving the people their industry and their ability to produce, they're going to give the exchange of, here, come to this location and have an experience. So instead of having life and producing and having a way to provide for your family, to be individualistic, to own your property, to explore and understand God's liberty for you and enjoy life as you have the guaranteed right to do, the globalists want to exchange that with sustainable goals or smart cities. And these smart cities will then be ventures to capture knowledge. They will increase the capacity of government to know things about you. This is ESG. This is communism. This is how it is going to happen. So whenever the Biden administration in April of 2022 said that it's going to do the America the Beautiful challenge to accelerate locally led conservation and restoration projects, these public-private grant programs are going to be giving money out. Now, I've linked this executive order in the description of this video, and one of those links talks to the America the Beautiful 2022 annual report. Now, this thing is a lot of pages, but in this summary, it's literally telling us, and I didn't clip this, it's telling us in this summary, let me bring this up. In this summary, it reads, no, this is where this is. In this summary, it says it's a public-private grant program. I read that. Now, it talks about... it gives equitable access. Where are we at? equitable access, workforce development, corridors, and connectivity, collaborative conservation consistent with the America Beautiful initiative. This is communism. This is how the globalists are going to it's how they're going to get their foot in the door for taking over agricultural lands, for taking over your properties, for reclassifying land use against the guaranteed rights of the people, and for whatever purposes the dear leaders in charge want to do. Now, what they're going to do is they're going to raise money. They're going to raise additional philanthropic and private support. So they're going to get rich people to do this. Rich people, globalists, World Economic Forum, probably Bill Gates, who knows? I have no idea in that regard. But these people are going to be doing these things, and what is it going to affect? It's going to affect the following: rivers, coasts, wetlands, watersheds. So basically, a watershed is really anything. If it rains on top of a hill and it flows downhill to a pond, that's a watershed. Everything therein, from the time that the water hits the earth from the hydrologic cycle to the time where it finds its resting place at level, that's a watershed. So this is going to be conserving restoring rivers, coast, watersheds, and wetlands, right? This is going to be connecting all sorts of stuff. Forests, grasslands, other important ecosystems as carbon sinks. This is your globalism coming in, Trojan horsing in under the guise of climate change or ESG, communism, all that kind of stuff. Okay, so I don't want to tell about the bads. You if you pay attention to me or if you're watching this, you understand this. But it's talking about how it's going to be working with. Let's go back there real fast because I want to bring up one last thing. They're working with. They tell you this is the same thing. They say we want to promise to conserve our land and water for generations to come. Now, I don't trust these people. These people locked the world down. These people lied to me. These people did all sorts of other stuff. They're going to be working in conjunction with the Department of Defense. Why is the Department of Defense going to be managing landscapes, sustainably managing landscapes? Why do we have increased access to federal funding? Why is there such a massive push for federal dollars to come in? So it's $375 for this, $10 million in grants, $25 million for invasive species. And that's the thing. If they find something that is going to be like the American burying beetle, then you can't build a road. Or they're going to have an eagle that prevents you from having cattle grazing your land or anything like that. Like, they're going to find something. And this is what it is. It's the bipartisan infrastructure law rural playbook to help state, local, tribal, territorial governments in rural areas unlock the benefits because they've been previously hidden from you. They've been previously taken from you. Guys, it's just wrong. It's globalism. That's what I'm trying to get. That's all I'm trying to get at is that this is globalism. This document here, it's linked below, goes on to explain the details of it. How they're going to do it. It's the report. How they're actually going to make this thing work. Now, let me explain generally what the scheme is. You take a county, like where I'm at in Rogers County. People own the property. There is public property. There is private property. There are laws, according to enactments, about how to do land usage. What this is doing is it's giving your county commissioners a lot of federal money, saying if you take this federal money, you can get bike trails, you can get historic scenic walks, you can get tourist attractions, you can get things to drive tourism, to increase money. And that's the lie. That's the red herring. The red herring is that your county commissioners will receive a bunch of federal money. They can then use that money to improve the aesthetics of your county, which on the surface level makes sense. They will also say that they're not going to touch your property. They're not going to mess with things. They're not going to change things. But if you take the money, the strings are attached. Who's to say that the same federal government that's now working with the Department of Interior, the Department of Agriculture, the Department of Defense, doing public-private partnerships that align with United Nations goals, why would they not change what they say after you take the money? After you take the money, now they got you in contract. So what I want to do today is walk through the common law way to destroy this. The common law way to stop this. So I'm doing this video Thursday, June 15, 2023. My county commissioners are going to be voting on this proposal on Tuesday. So that's Thursday, Friday, Saturday, Sunday, Monday, Tuesday. 6 days from now, if you count today as a full day, they're going to be voting for or against this proposal. Now, as it stands, all three of my county commissioners, these guys right here, all three of my county commissioners are on board with this. The pushback from the people has been vociferous. It has been vehement. People hate this idea. They hate it because they understand that it is globalism. They understand that it is collectivism. They understand that it is not good. Now, these three men, and I know all of them personally to varying degrees, these three men may not understand the far-reaching effects of what I just laid out. These three men probably have, and I've heard that they have, attorneys that are working in conjunction with the contractors. The consultants for this America the Beautiful here is the Sentinel Landscape Partnership. This talks about how the Sentinel Landscape Partnership is a coalition of federal agencies, state and local governments, and non-governmental organizations. Do you see that right there? You have the government working with the not government. So you've got the government working with the not government, and what are they doing? Working with willing landowners and land managers to advance sustainable land use practices around military installations and ranges. So these are consultants that come in and talk to your county commissioners and say, hey, there's a bunch of federal money. If you take this federal money, we can improve the tourism, we can improve the tax revenue, which seems to be all that elected officials are doing. And so my three county commissioners, Dan DeLozier, Steve Hendricks, and Ron Burrows, these three men are going to, for all indications, are going to vote for the project. They're going to greenlight it, and they're going to say, okay, let's do this thing. Let's open it up. Let's receive the money, and let's start making changes. Let's start altering land use and the way that things are in Rogers County, Oklahoma. And yours truly is against it. Not just me, but the people in Rogers County. People hate this thing. And I don't know the heart of these three men on this issue. I don't know how they think about things on this issue. So without taking a chance and without trying to, appeal to their good conscience, I did what is a common law action, and I hand delivered today the following notice to all three of them. And that's what I want to cover for you right now. So this is exactly what I gave them this morning. So I said to Dan DeLozier, Steve Hendricks, this is the Word document that I used, Dan DeLozier, Steve Hendricks, and Ron Burrows. I hand-delivered all of them. So it says, notice of maladministration and unlawful trespass of guaranteed rights. Now, what I want to do is I need to explain every single thing that we're doing, and that way you know. So here we have our Black's Law Dictionary, 4th edition. The Black's Law Dictionary is what judges, courts, and lawyers use to determine the meanings of words. Black's Law Dictionary. And if we go to maladministration, we can find this term is used in the law books interchangeably with misadministration, and both words mean wrong administration. So if I'm telling them that they have maladministration, then what I'm really telling them is that they're doing their job wrong. They're mismanaging, they're misadministrating government. Okay? So the maladministration and unlawful. Unlawful is not illegal. Unlawful means that it's against the law of the land, which is the Constitution. So something that is unlawful is unconstitutional. Trespass, we are violating something. We are going against something of someone else's. In this case, the thing that's going against is guaranteed rights. Okay? Notice to I can look up all these definitions. I'll only look up the ones that people probably don't have a decent grasp on. But in America, by common law, you have rights. Those rights are given to you by God because our founders loved Jesus and they believe the Bible to be true. And so because of that, your rights, the definition of right is power of free action. The reason why we have secured rights is because God Jesus Christ gave the Great Commission. He says, all authority is in heaven and earth is given to me. Go ye therefore, baptize, teach people, baptize the name of the Father, the Son, and the Holy Spirit, and teach the nations to obey all of my commands. That is power that Christ has given us. He's given the church. That power that the church is given in the government speak is your right, because your right is the power of free action. And we can look in the I'll just do that. That way we have understanding. So let's look up right in the Black's Law Dictionary. We go to our Black's Law Dictionary. We look up the word right. And it's huge. That's all right. That's all the words for right. But this here says it's the powers of free action. Rights are defined generally as powers of free action. That power of free action comes from God, because your rights come from God, and the powers of free action is speaking to Jesus Christ, telling the church to go make the world Christian. That's why I believe in a victorious gospel, because the gospel is true. Believe the gospel. Amen. Now this says, notice to agent is notice to principal. This means that I gave this to their secretary. And if you're a public official, if you have a secretary, your secretary is someone who is an agent. They are in your place. And they are able to receive legal and lawful correspondence. This notice is lawful correspondence. So if I gave it to the secretary, it's the same as though I gave it to the principal. This is the elected official. So if the elected official has a secretary and you give it to the secretary, it's the same as though you give it to the elected official. And then the notice to a principal is notice to agent. So if I gave this notice to one of my county commissioners, it's the same as though that county commissioner now has the knowledge that then affects all of his agents. It is reflexive. They can't get away from it. And this is designed, we put this in here to specify, to express the fact that if I give it to whomever, I am delivering the correspondence. Okay, I will say, just as a quick tidbit for me, as we're going in this, if you want to support my work and take the money that you're already spending on household goods, and you want to take that to companies that are not Walmart or BlackRock or Globalists or these types of situations, go to patriotswitch.com/Jaron, patriotswitch.com/Jaron. I intend, by God's grace, to take this knowledge around the nation so that people can start to understand the common law, so that they can live and move by the common law, and that they can correct their government. So if you want me to continue to do this with the potential that people use the law, understand the law, and destroy globalism by sending little pieces of paper in the mail because it expresses what the law is, please be a supporter and go to patriotswitch.com/Jaron. I appreciate you. Now, let's go back to what we were talking about here. And it says, I, Jaron Jackson, so I'm writing this in the first person, and I'm one of the people, as seen in Oklahoma Constitution, Article 2, Section 1. So let's go to our Article 2, Section 1 of the Oklahoma Constitution. You can go to Ballotpedia. Just go to Ballotpedia and type in Ballotpedia State Constitution. We scroll down all the way to Oklahoma. We click on Oklahoma. We scroll down to the Bill of Rights in Oklahoma, and we click on here. And we look on Section 1, Article 2. Here we go, Article 2 of the Oklahoma Constitution, Section 1. And it says what? All political power is inherent in the people. So Jaron is coming as one of the people. And all political power, you see here, all political power is inherent in the people. So whenever I come to my government, whenever I come to my county commissioners as one of the people, I'm coming to them as one who has all political power, and I reference Article 2, Section 1 of the Constitution. Now, there are other constitutions that have this same thing. I mean, if I go all the way up to, let's just name a random state. Let's just go South Dakota. If I go to South Dakota, you go down there, we're looking for their rights. Where are your rights? Bill of Rights, Article 6, South Dakota Constitution. All men are born equal and independent, certain inherent rights. There you go. So, they have, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So there you go. All political power there is with the people as well. And you can go down all of your all of your rights. So it's really important for you to understand your state constitutions, because they are trust indentures, and they actually have more power because they enumerate more rights than the federal constitution, the U.S. Constitution. Okay, so let's go back to our notice. As we go back to our notice here, it's Republican in form. Okay, so let's look up, what does Republican in form mean? Let's go to our handy dandy Black's Law Dictionary, and we look up republic. A republic is that form of government in which the administration of affairs is open to all the citizens. Right? So it's a form of government that is open to all the citizens. A Republican government is a government in the Republican form, a government of the people. Of the people. Remember, the people have all political power. So it's a government that has representatives chosen by the people. So the people are the ones that choose the representatives. So no representatives have any power in the government unless the people have chosen. Make sense? So that is what we're doing, and that's what we're coming. Now, sui juris, this is where I want to go to. I want to specify what is my jurisdiction. This is my standing. In the law, you have to have standing, or else you don't have a court case. You can't bring anything to the court if you don't have the right. And so, by going to Black's Law Dictionary, sui juris, we're going to look up here. Black's Law Dictionary, sui juris is Latin, of his own right. Possessing full social and civil rights, not under any legal disability or the power of another, or guardianship, having capacity to manage one's own affairs, not under legal disability to act for oneself. I'm not a child. I'm not mentally handicapped. I'm not someone who has, I have no legal disability. And so I'm coming to them sui juris, which is of my own right. How do I know that? Because I know that my rights come from God, which is really specifying that I have the power of free action. So I'm coming to the government of my own volition, by my own right, and the government that I'm coming to is republic in form, which means the administration of a republic is open to all. And we just saw in the Constitution that the people have all political power. So here I am one of the people, using my inherent political power, coming by right from God to a government that is open to the administration of, its affairs is open to the administration. That's what's happening. So I have standing, I have lawful standing, I have jurisdiction, I have the power, and I'm bringing all of that to make this notice, okay? So whenever we give notice, so I do notice you, Dan DeLozier, Steve Hendricks, Ron Burrows, those guys are my county commissioners. So those are my county commissioners. So I'm noticing my county commissioners, and that this may you provide immediate due care. Hey, I'm bringing I'm one of the people. I'm your boss, and I'm bringing you something that you may provide immediate due care. Okay. Please take notice. Now, I bold this, and I say each idea I'm going to specify with the please take notice. That the Imagine Rogers County Comprehensive Plan, that's the globalist scheme, that's the Trojan horse, is maladministration of government and a trespass on the people's guaranteed right to property. I like to, up front, simply say what the issue is. Put your bottom line up front. This is like an army thing. So right up front, I'm telling them that the thing that they're looking to vote on is wrong administration of government and a trespass on the people's guaranteed right to property. Now, wrong administration, they don't have to have done it. They just, as I'll get to it later, they just have to think about it. If people that are sworn under oath to the Constitution just think about doing something that's wrong and against the form of government, that's maladministration. You cannot even think about giving a form of government or using government powers that are outside my control or outside the Republican form of government. And you can't trespass. You can't violate my guaranteed right to properties. See authorities below. I'm going to list my authorities below. Please take notice that the county commissioners, let me make sure that you guys can see this. Yeah, please take notice that the county commissioners have no authority to interfere with the people's right to property. That's true. Nor are they able to endanger the people of Rogers County with maladministration. See authorities below. Now, what I'm using here is a maxim of law. See if I can look that up real fast. I want to look up a maxim, and that way you guys understand what maxims are. Okay, here we go. Let's go here. A maxim. Maxims are but attempted general statements of rules of law and are law only to the extent of application in adjudicated cases. Right? So Koch, this guy is one of the most important and significant jurists in the common law, defines a maxim to be conclusion of reason. And he says that it is so called, and he gives a Latin phrase, but that Latin phrase is, a maxim is a proposition to be of all men confessed and granted without proof, argument, or discourse. So whenever you give a maxim, like I did here, this maxim, the derivative power cannot be greater than the original from which is derived. This is the conclusion of reason in law. You cannot argue with this. This has been proven true. You cannot disprove it. So whenever you come up to a court or a lawyer or a public official or anybody and you use a maxim of law, there is no arguing against it as long as it's applied appropriately. And here I'm saying that the county commissioners don't have the authority. Now, where did the county commissioners get their authority? They got it from the Constitution. Well, they got it from the charter, and the charter got it from the state statute. The state statute came about from the state legislature. The state legislature came about from the Constitution, and the Constitution came about from the people. So the people created the Oklahoma Constitution. The Oklahoma Constitution granted the legislature to exist. Then it granted powers to that legislature. That legislature then wrote statutes, Title 19, we'll get there. Those statutes then enumerate what the corporate charters of the counties are allowed to do. So whenever county commissioners are using authority, they can't use authority that go against the sovereigns. The political sovereigns, the popular sovereigns in this nation, in this state, as I just showed you, they have all political power. You can't, the derivative power, that of the county commissioners, can't be greater than the original from which is derived. The county commissioners cannot do anything that goes against the people. Can't do it. And that's a maxim of law. So no attorney, no judge, no court can argue against that. That is a perfect form of reasoning. Okay? Now I say, please take notice that Black's Law Dictionary, 4th edition, defines maladministration as wrong administration. I already showed you that. Then we say, please take notice that the people have a guaranteed and absolute right to property, which is true. Now understand that whenever the court says that you can't have an absolute right to free speech, there is a difference between using your rights in private and using your rights in public. If I go in the public and I yell fire in a crowded theater, I am in public. I do not have the public right to scream anything in public. However, I am on my own property, and I can scream whatever I want. And so if I own my property, and my property is private, I can use my property for whatever purpose I want, so long as I do not trespass the rights of others. So if I am not trespassing the rights of others, and you would have to come at me with, 2 sworn statements to just, allege probable cause. You can't just rewrite my property to be zoned according to some federal statute or some state statute. We're going to get there in a second. But the people have a guaranteed right of absolute property, which includes the liberty to acquire. I can buy stuff. I can maintain. I can use my property for whatever. I can keep my property for whatever I want. And I can use for their benefit and good. If I want to dig a big hole in the ground, I can dig a big hole in the ground. If I want to build a skyscraper, I can build a skyscraper. I can do whatever I want on my property because that is my right. You will learn very quickly that our rights are trespassed by many fictions and colors of law. Anyway, and there can be no rule, policy, plan, or the like that goes against the right of the people without express written consent. If you try to make a rule and I don't consent to it, you can't do it. Now, if I tell you, hey, you can trespass my rights, okay, well then you've just been granted permission, and now you can trespass the rights. And now I'm quoting from a Supreme Court case, Miranda versus Arizona, that says, quote, where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Now, I want to be very specific here, because not all courts speak on matters of the law of the land. Let me bring up law of the land real fast, because some people don't understand what that is. So let's go back to our Black's Law Dictionary, and we'll look up law of the land. So we go to our law of the land, right there. Law of the land is due process of law. The meaning is that every citizen shall hold his life, liberty, property, and immunities under the protection of general rules which govern society. If we turn this page, everything which may pass under the form of an enactment is not the law of the land. So if the state legislature passes an enactment, Title 19, which we're going to get there, that enactment is not the law of the land. Why does this matter? Because if we go to our Constitution, and I didn't look this up, so let me get this ready to rock. My phone is being slow. Let me bring up my Constitution. If I bring up my Constitution and I go to Article 6, come on camera, I go to Article 6, and I go to Clause 2, the Constitution says that this Constitution, the laws of the United States shall be in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state, including Oklahoma, shall be bound thereby, anything in the Constitution or laws of the state to the contrary notwithstanding. So this is saying the Constitution is the supreme law of the land. And if anything goes against it, they do not have standing. Remember whenever I said that I have standing because I'm there sui juris? I've got the jurisdiction. I'm coming as one of the people. I have standing. I have jurisdiction. I can come to the republic and tell my trustees, my servants, what to do. I can instruct them on how to be lawful. And that's what we're doing. So if we go back to our thing here, no one can have any rulemaking, which is exactly what they're doing. No legislation, which is exactly what this Reimagine Oklahoma is, or Rogers County is. They can't do it. Please take notice that writing ambiguous policies in pursuance to Title 19, we're going to go there real fast, of the Oklahoma statutes to deal with the county development has nothing to do with the common rights of the people. Derivative, so it's down from, it's a product of the common law that you swore to as trustees to protect on the condition for receiving employment of the people's servants, or as the people's employment. So let's go to Title 19 of the Oklahoma legislature. So here's the Oklahoma statutes, and this is Title 19. Now, what the county is looking at is they are looking at Title, where are we at? They're looking at Section 19, where are we at? They're looking right here, Metropolitan Comprehensive Plan. They're looking at Title 19, Section 866.10, the Common Law Comprehensive Plan. This is what they're looking at, and this is page 353, so it's 866.10. So scroll down, sorry to mess your eyes up, 866.10, go back up, excuse me, 866.10, 866, 867, 866.33, 30, sorry folks, I've got it blown up to where you can see it better, which means I can't see it that well, so I've got to scroll like this. So if we go to So if we go to 866.10, there's 12. There's, where are you at? 86610. There we go. Metropolitan Comprehensive Plan. The Metropolitan Area Planning Commission, so this is not even the county, it's just a planning commission, shall prepare, and so this planning commission is under the jurisdiction of the county. So now the county is a created fiction. It's led by the county commissioners. These county commissioners are in charge of a corporate fiction called the Planning Commission, and the Planning Commission shall prepare. Doesn't mean must, it just says shall. There's a difference between shall and must, by the way. And from time to time revise. So that means that's how you know it's really up to the discretion of the people involved, because it's saying from time to time. From time to time, they can do whatever they want. They shall do it, which doesn't mean that they must do it. And because they don't have to do it, they're choosing to do it. And now they're choosing to do it. Why? Because there's money. There's money brought to them. There's money now being offered through the American the Beautiful program, and there's now consultants that are working with them to bring these guys an offer, a contract offer. And that contract offer is saying, hey, this is time. You're now being offered a contract. Hey, this contract, you can do what? This comprehensive shall be developed. Purpose of bringing about an orderly, coordinated physical development in accordance with the present and future needs of the area. Right? So they're just assuming this stuff. They're just saying that you can do these things. Right? So this is what Title 19 of the Oklahoma statutes are saying. So writing ambiguous policies. And this is the problem with this type of language, because whenever you can see that, hey, it's the present and future needs of such area, that's ambiguous. What area? The county? My land? My neighborhood? That watershed? That river? That coast? That field? What area? See, it's broad and ambiguous. And because it's broad and ambiguous, it allows for people who've got a lot of money to make contract offers, to work with consultants, to go towards people who think that they're doing something good to improve in tourism and collection of revenue or whatnot, and they're doing it all according to some statutes that people are going to tell them you have to do this. And so they don't know what to say. So now they're in pursuance of Title 19 of Oklahoma statutes, and they have nothing to do with the common rights of the people. How do I know that? Well, because the rights of the people, here's my rights. All political powers inherit the people. The government is instituted for their protection. Whose protection? The people's protection. So right here you have an interest. The people have an interest directly against the interest of what? The Metropolitan Comprehensive Plan. There is a conflict of interest. There's a controversy. There's a controversy in the law. You have a third-party consultant having money from the federal government coming to local actors, elected government officials, saying, we have a proposal for you that you shall, from time to time, go ahead and do stuff. And that is in direct contradistinction to the people's right. You are going against my inherent rights to life, liberty, pursuit of happiness, and the enjoyment of the gains of my industry. By the which way, if you pay taxes in Oklahoma, read that right there. You have the enjoyment to the gains of your industry. But that's not what we're going to talk about today. So we're going to talk about the Metropolitan Comprehensive Plan. This is what these men right here are saying that they can't stop. Because this consultant are coming with a bunch of money in conjunction with to beautify America, because we all want to beautify America, right? And as they're beautifying America, they got themselves a statutes, and now they're coming to the people saying, we're going to be doing stuff. And I'm saying you can't do that, that you are a trustee. Now, how do I know that they're a trustee? Well, we can go back to our Constitution. Let me get up my Constitution here real fast. Article 6, Clause 3. Let's go back to my handy-dandy hand cam. Handy-dandy hand cam. This is Article 6, Section 3. It says that, it talks about the Constitution. It says, no religious test shall ever be required as qualification in any office or public trust of the United States. Well, what's a public trust? So now let's go back to our Black's Law Dictionary. Let's look up trust. T-R-U-S-T. If we look up T-R-U-S-T, we find a trust is right there, but now we want a public trust. Public trust is one constituted for the benefit either of the public at large or some considerable portion of it answering a particular description, right? And if you look at a trust, it's of right of property, real or personal, held by one party for the benefit of another. So whenever you elect politicians, whenever Rogers County ostensibly elected these guys right here, these guys only have power to uphold the Constitution for the benefit of the people because they are in a trust. And they cannot use the powers of the trust. They cannot use their power as county commissioners to go against the people. They can't do it because this is a public trust. And that's what I'm saying right here. You swore as trustees to protect as a condition for receiving employment as the people's servants. The comprehensive plan expresses, which just means it's written, the objective to alter land use, change the people's customs and historical understandings of Rogers County, and aligns the governing objectives and strategies with third parties not sworn to the Constitution. Those are all true. They want to change the use of the land, bike trails, goating trails, historic trails, this and that and other things. That is altering the use of the land as it currently lays. That's a true statement. They want to change the people's customs and historical understanding of Rogers County. They want to divide the county up to call it stupid stuff like Prairie Gate and Stupidville and all sorts of other dumb things. It's just dumb. People here don't think like that. But the purpose of what they're trying to do, if I can bring this up, so the godless commies are trying to this is called name placing, and this is how they do the ESG. So let's just take Rogers County. These people want to divide Rogers County up into 4 like subsections, right? and Claremore, which is right there in the center. And each one of these places is going to have its own, ESG score. You're going to have bike trails here. You're going to have, fishing here. You're going to have a nice scenic walk here. You're going to get the money. They're going to establish these things. Then they're going to do regionalism, and they're going to say this area has an ESG score of 10. So we're not going to increase your property tax. But if your ESG score is a 2, we're going to fine you because you're not upholding the regionalism, the value, the currency, the brand, the name placing of that area. So that's the plan. That's the plan. That's how the godless commies are going to do it. That's how they intend to do it. And they're going to do it through private-public partnerships. And so, whenever you go back and you see that the Biden administration is giving money, they're going to do it through this. They're going to do consultants, and they're going to come to your county commissioners. They're going to use statutes, and they're going to do that against the interests of the people. The way that we respond is by notice. And we're saying, you guys are changing the people's customs and historical understanding of Rogers County. True. You're aligning governing objectives and strategies with third parties not sworn to the Oklahoma Constitution. I want good government. I want a Republican form of government. That's the objective of government. How do I know that? Well, what's the purpose of government? Government is instituted for their protection, the people's protection, not name placing, not ESG scores, not that stupid crap that they're trying to push. It's for my security and my benefit. Promote the general welfare. The general welfare is not collectivization of private property. Okay? So, the Imagine Rogers County Comprehensive Plan establishes precedent for federal jurisdiction, and that's the objective. The federal government wants to get control of agricultural land. You saw here in this executive order, they want to do what? Conserving rivers, coast, wetlands, watersheds, forests, grasslands, other important ecosystems as carbon sinks, because that's a climate change lie, amen? Wildlife corridors, that could be anything. Where does wildlife exist? Freaking everywhere. That's a wildlife corridor. That's a large landscape. You see, these words are ambiguous. They mean everything. They mean everything and nothing simultaneously. So our task as the people we have to say what the controversy is. The controversy here is that the people have guaranteed rights, and the government is being used outside of its form to trespass those rights. And so what I'm expressing in this notice is that you can't do that. You can't grant unlawful presumptions on property. You can't call my property part of the ESG ecosystem. You can't call my acreage part of, I'll push the wrong button. You can't call my property part of this. My property is not part of something that's going to have an ESG score. You can't do that. That is an unlawful presumption on my property. You can't even consider to think about my property in an unlawful manner. That's called maladministration. Maladministration is wrong administration. So if the county commissioners are even thinking about doing this, they are wrongly administering a Republican form of government. Okay? So, let's keep going, because we got a lot more. So please take notice that you do not have the constitutional power or authority to do that. True, they don't. And I give another maxim. No one can grant or convey what he does not own. These men here, these county commissioners, do not own the people's property. They do not own your property. Where's Section 7? Section 7 says, deprived of life, liberty, property without the due process of law. Due process of law, by the way, is by a jury of your peers, not just because some county commissioner passed an ordinance. Make sense? Why? How do I know this? Because we are the law of the land. All right? So, the controversy in the law is that those county commissioners are considering contracting with a third-party vendor using federal funds to presume unlawful jurisdictions and considerations, classifications, and construction of law against my property. So please take notice, the people, we understand that you don't dictate property use, acquisition, development, distribution, zoning, or classifications. Now here is what I'm doing. I'm actually trapping them here. Because what I intend to do is to say that you guys can't dictate this. Right now, I believe that the county commissioners and most elected officials think that whenever they get the power, they can do what's been done. And they'll have an attorney. And again, my father was an attorney. I love attorneys. My father-in-law is an attorney. I don't have an axe to grind against attorneys. But if an attorney is going to look at some county commissioner and say that the statute, right? This statute right here says that you shall do this. If some attorney tells some county commissioner, hey, you've got this statute that you shall do this Metropolitan Comprehensive Plan, if that's what they're doing, that is a controversy in the law against my property because it's without my due process. You can't do that. Okay? So what I'm saying is that you can't dictate property use, acquisition, development, distribution, zoning, or classification. And this is where, just to be frank, just to be candid, I'm setting a trap. The lawful trap that I'm setting is that I want that attorney to say, yes, county commissioner, you can do that. Because I want the county commissioner to listen to what the law is, because I want him to see what the law is versus what his advice is. I want to see that distinction. I want that county commissioner to see the people are telling you what your job is. The people are telling you what the law is. That lawyer is saying you can do this because of this statute. I want that distinction. I want the elected official to listen to the people. I do not want that elected official to listen to the unelected contracted lawyer. Make sense? The trap is whenever the county commissioner receives in his ear the counsel that they can zone property, they can do the planning, they can do those things. That's where we're going to come back later and we're going to go towards the initiative. Because any power that the county commissioner has been granted to him. And so if the county commissioner is using power, the county commissioner has received power. And who has all political power? The people. So if the county commissioner has received power, who gave it to him? And so if the county commissioner thinks that he can zone, if the county commissioner thinks that he can do classifications and he can contract and he can do all those things, where did he get that power from? He got it from the people, because the county commissioner was chosen by the people, but the county commissioner must conduct his business according to the corporate charter of the county. The corporate charter of the county is outlined in Title 19, the Oklahoma statutes, which only came about from an enactment of the Oklahoma State Legislature, which only existed because the legislature is only defined and expressed and given powers according to the Oklahoma Constitution, and the Oklahoma Constitution only exists because of the people. Okay, so you have to travel all the way up to the source of political power, which is the people. All right, let's go. Let's keep going. So you may have enjoyed attorneys' opinions expressing your power to make this decision, or third-party consultants whose job it is to persuade you that this is for the public good. That's a shout out to these guys. That's me saying, hey, you guys might have consultants to tell you this, but that's not the truth. But the people are now educated. Oh, shoot. I did something I shouldn't have done. Control Z. Control Z saves my life. But the people are now educated, no longer willing to acquiesce to their servants' actions contrary to the Oklahoma Constitution or the free use of their guaranteed rights. We now know what you're doing, and we don't want to go along with it anymore. John Locke writes in his book, "'Tis true, the civil lawyers have pretended to determine some of these cases concerning the succession of princes." Now, this princes isn't necessarily a prince royalty. It's the prince, it's the magistrate, it's the people who have power. So the lawyers have an area, have a heritage of getting involved with the issues of magistrates. And magistrates swing the sword for God. That's Romans 13. But of our author's principles, they have meddled in a matter that belongs not to them. This is John Locke back in the 1600s saying that lawyers will usually always try to get involved in things that don't belong to them. I want to point this out. I want to go to my handy dandy hand cam real fast. Gotta push this. Let's go to Luke chapter 11, verse 52 of our King James Bible. This is Jesus talking. "Woe unto you lawyers, for you have taken away the key of knowledge. Ye have not entered in yourselves, and them that were entering in ye hindered." Lawyers have a tendency to hide knowledge. Why is that? Because they have a profession in the realm of words. Their profession is in the realm of abstraction. It's in the spoken word. It's in the fabrications of the mind. Government isn't like a thing. It's not a real thing like I am, like you are. You and I are real. Government is a fiction that we all believe exists. And so if lawyers control the words that are spoken, then the lawyers control the knowledge and the ideas that people believe about government. So what we're talking about here is, this is our author's principles. They have meddled in a matter that doesn't belong to them. If attorneys come along, and again, my father was an attorney. I'm not against attorneys. I'm not against attorneys, and most people just haven't been taught the law. But if they're saying this, this matter doesn't involve them. Okay, so let's keep going. Smart cities, you guys have heard about that. Sustainable policy objectives work contrary to the rights of the people. That's the contrast I want. That's the controversy in the law that I want. I want this controversy. The controversy in the law means that there has to be a decision. Now that I'm telling you that you are against me, there has to be a decision. I'm putting you on notice that you are against me. Now we have a grounds for justice. Now we have a grounds for seeking remedy. Okay? It goes against the people, goes against a Republican form of government because it contracts with third-party vendors that are not they're not accountable to the Constitution. It takes federal money, right? It lays out federal proposals that try to change the use of land, and candidly, it railroads. It just tramples over my elected officials. If my elected officials come and get leaned on or get, wined and dined by some consultants with a bunch of federal money or private money, then how do I expect my local yokel elected officials to respond whenever all these people with all this stuff comes to their door? Okay? So these men right here, they might actually not like this proposal, but they're going to vote for it. The trajectory is that they're going to vote for it because they don't know how to stop it. The lawyers are telling them that they have. This is the statute. This is the statute right here. You have to do it. And so what we're doing is we're telling them, hey, that's not the case anymore. So as they contract with third parties to function as a governing body in lieu of granted constitutional powers and open administration of government. You guys are going to contract with people instead of doing your job as the government. So they augment capacity for the government's knowledge and information collection contrary to secured right to privacy. See how I'm showing the conflict. I'm showing, hey, if you guys get smart cities, you're going to be able to collect a lot of information, and that works against my secured right to privacy. So if you go along with the Imagine Rogers County Comprehensive Plan, like the globalists want you to, you're setting conditions to do additional trespass against guaranteed rights. You can't do that. And expressly, which is a way of saying that it's written, intend to conduct rulemaking that trespass the rights of the people, including land use, acquisition, distribution, and classification of property. This is those name placing areas. This is establishing social credit scores. This is changing the use of the land, even to create a bike trail. If there is currently not a bike trail, and they want to create a bike trail, then they have changed the use of the land for the bike trail. And so this is technically saying, yeah, it's right. Now, I might like bike trails. I might want hiking lanes or all those kinds of things. But if you're doing it with federal money, you're doing it with federal strings attached. So don't fall prey. Don't give away your rights just because, don't give away your rights just because of these people, okay? And so what I do is I always kind of do this. I always just say copyright Jaron Jackson in the bottom, because really under copyright law, all you have to do is make an effort to copyright, to say that, or to express that you've copywritten. And so if some lawyer or some politician wanted to take this and then reproduce it without my permission, they're going against copyright law. And so if someone were to take what I'm writing and then really drill into it and say, well, this is illegal, go get him, what I've just done is I've now secured their inability to recreate or reproduce this instrument to use against me. And if they do it, well, now I've got legal action I can take against them for reproducing something that I've copywritten. Just another hiccup, just another trick to go against them. Just another protection, I should say. So please take notice that trustees, again, that's elected officials, because they're sworn to a public trust, just by considering the project, commit maladministration as it works against the fundamental principles of the law that guarantee the Oklahoma Constitution, as we've said. Now, here I go and I give evidence. The evidence is the law. This is the common law. This is the ratified, trust indenture of the government. Article 2, Section 1 talks about the political power. That is just here. All I've done is, posted what the Constitution says. Article 2, Section 1 is Article 2, Section 1. Article 2, Section 7 is Article 2, Section 7. That's all I've done. Article 2, Section 30, unreasonable searches and seizures. Well, you know where I'm going with this. Article 2, Section 30 comes down here. Unreasonable searches and seizures. Okay, all that I've done is I've quoted what the Constitution is. Now, Article 15, Section 1, Oath of Office. Let's go back. Article 15. So we got to go here. We got to go down to Article 15 of the Oklahoma Constitution. Oath of Office. Click. There you go. Officers required to take oath. There's your oath. Right? And every constitution has this. It may be different articles. It may be a different frame. It may be a different layout. But, it's in there. Now, the Constitution of the United States, Article 4, Section 4, guarantees me the right to a republican form of government. How do I know that? Well, I just quoted it for you. So let's go to our handy-dandy cam, and we'll say Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government. So they have to, I'm guaranteed a republican form of government. If I don't have a republican form of government, then they breach the trust. So then I say, when anything is prohibited directly, it is prohibited also indirectly. This is a maxim. So whenever the Constitution says that the right of the people should be secure in their houses, papers, effects against unreasonable searches and seizures, and it can't be violated, that means that you can't come up and make smart cities whereby as I'm traveling, as I'm exercising my right to travel, or if I'm exercising my right to be in public, I've got the expectation not to have my face scanned. How do I know that? Well, because I have reasonable expectation. Now, you may be saying, Jaron, you're in public and you have no right to go against that. Well, if you are one of the people and you're trying to, let's say this, we're protesting on the side of the road, or I'm on the sidewalk, which is public property, and I'm saying no more abortion, or abortion's a baby murder, which it is, so don't go abort your babies. God hates the shedding of innocent blood. If someone comes up to me and starts filming, I don't have an expectation of privacy because I'm exercising my public right publicly, and someone else is exercising their public right publicly. They have the public right to that of the press. They can record me. They can capture me on that way. The difference is the government doesn't have those rights. The government doesn't have a public right that competes against my public right. Well, how do I know that? Because God gives rights, and rights aren't given to government unless they've been granted by the people. So if the people in this instrument are telling the government, you can't do smart cities, it's bad for us, then the government no longer has that right. The government, therefore, can't make the presumption that it does because we're telling it that it doesn't. So if the government continues to think that it can do smart cities, it can have sustainable policy, it can do all these other types of things, that is a presumption. It is presuming that it can. So what we're going to do is we say, no, if you do, that's wrong administration. That's maladministration. And we can say that because we have all political power. Does that make sense? That's the distinction that you need to understand. Okay, so let's go back. We said all this. Please take notice that the people understand your limited powers granted to the Oklahoma Constitution in regards to property to a Republican form of government, and would like to believe that you are not presenting the imagined Rogers County Comprehensive Plan as an attempt to block the people's free enjoyment of property, privacy, or the genius of free government. Now, I'm doing this to give grace. I'm doing this to make sure that my elected officials don't think that it's me versus them. I'm not against them because I am their boss. I'm one of the people. I'm coming sui juris because I've got the right to do so. And because I'm coming to these people and I'm giving them notice, which is just a way of saying I'm observing this, I observe this, I say this so that you may provide immediate due care. And if they, because they're trustees sworn to the Constitution, do their job, they will hear me out because I'm petitioning them, I'm expressing my will as one of the people. And by doing this, now they know. So whenever I come back and I say, I don't think that you're doing this to hurt me, so I would like to believe that you are not presenting the imagined Rogers County Comprehensive Plan as an attempt to block the people's free enjoyment of property, privacy, or genius of free government. Now you might think, why does Jaron say genius of free government? Because this is why you need to know your constitutions. If we go back to Article 2 of the Oklahoma Constitution, where are you at, Article 2? We go back to Article 2 of the Constitution, we look up Bill of Rights, and we come all the way down to genius government. Where is it at? I think it's 15 or 14. Here we go, 15. No, that's not it. It's monopolies. Where are you at, monopolies? This is where you need to know your constitution. I should have written this down, but it's in here because I've seen it. I've read it. It's written. There we go. Section 32. Perpetuities and monopolies are contrary to the genius of free government. Now, if they sign up with a consultant, because that consultant now contracts with them because of money, what has my government just done? They've created a perpetuity. They have created a monopoly. The government cannot create a perpetuity or a monopoly. Why? Because they are contrary to the genius of free government. So whenever I say in my notice that you are going to do this and it's going to block the people's free enjoyment of property, privacy, and the genius of free government, I'm setting them up to violate another right. Because this is saying I have the right to no perpetuity. As one of the people, I have the right to no monopoly. I have the right to genius and free government. And so if they set up a perpetuity, because the conservation of land is what the government wants, if they set up a contract with a third party that's not from where I'm at, then that is a monopoly because they haven't contracted with any third parties from the county. They ain't coming to me asking me if I want to take a bunch of money to go dig out a bike trail. They haven't done any of that stuff. What they've done is they've contracted to create a monopoly, to create a perpetuity, and that deprives me the right of genius-free government. So that's why I said it. You deprive me of the genius of free government. The Oklahoma statute used for this plan, Title 19, specifically states the counties cannot exercise power to the contrary of the sovereign. Now remember whenever I said that they're using this section, Title 19, Section 866.10, a Metropolitan Comprehensive Plan? Remember whenever I said that? They are using this. They are using this to justify these guys right here, either by themselves or some attorney, or they've been lobbied by some consultant. These guys right here believe that they're functioning under this statute right here to do a Metropolitan Comprehensive Plan. And as they're doing a Metropolitan Comprehensive Plan, I have said that that is in contradistinction to this, because you're depriving me of the genius of a free government. But what I'm also doing in my notice is I'm saying that the exact statute that you're using says you can't go against the power contrary to the sovereign power. Now, who's the sovereign power? Oklahoma Constitution, Section 1, or Article 2, Section 1, all political powers inherent in the people. You cannot go against the power of the people. And the statute that you quote, Title 19, says as much. In fact, it's Title 19, Section 8.5. So if I go up to Title 19 and I go way back up to Section 8.5, where are we at? 8.5, that's 131, keep going. And by the way, if you want to support my work and how I do all this stuff, right there, patriotswitch.com/Jaron, patriotswitch.com/Jaron. Take your money out of the deep state and the swamp and the godless commies and give it to an American-made company. Go there, sign up, and someone will be in contact with you to switch your money that you already spend over to an American company, and it also supports my work, this work, and helps me go around the country and talk to people about this right here. This is the common law. Here we go. Section 19.8.5. Charter provision contrary to or inconsistent with sovereignty and public policy. Isn't that what I wrote? And then it says, nothing contained in this act shall be deemed to authorize, right? Which means you have been granted the authority. So nothing in this act. What's the act? Title 19. Title 19 cannot be what? Cannot be deemed. You can't conclude. You can't decide. You can't judge. You can't determine that you have the authority or the adoption of the charter provisions. What's the charter provisions? Well, that's the county. That's Title 19. That's talking about the county. Contrary, which means opposite. What have I done in this notice? In this notice, what have I done? I've said you've done what? You've worked contrary. I've said you've worked contrary to the rights of the people. And the rights of the people are the who? All political power is inherent in the people. If you do this plan, if you so much as think about this plan, you are working contrary to the rights of them. I'm saying you can't do that. You can't work against the people. Okay, so now I'm showing them in the act, in the statute that they stand on, nothing can be contained in this act shall deem to be the adoption of charter provisions contrary to or inconsistent with the sovereignty, that's the people, and established public policies of this state, Oklahoma, and no provision having such effect shall be valid. Meaning, you cannot pass your stupid Imagine Rogers County Comprehensive Plan because it goes against the rights of the people, it goes against your authority as a trustee to the government, and the statute that you're quoting from literally tells you that it can't. Okay? This is dead. Dead. Don't do it. You're acting unlawfully, which is why we're telling them you have bad administration and you're acting unlawfully. That's what we're telling them. We're telling them you're doing a bad job. Stop it. Keep going. Please take notice. As the people, we recognize that you can't use power against the people's guaranteed rights, nor can you make a rule, because that's what this is. Your rule is the Planning Commission, that would infringe against the right of the people or the sovereign powers that delegated you that authority. How do we know that? We are a republic. The people constituted and ratified the Constitution. The constitutions are public trusts. The elected officials are trustees. They can only use the power that they've been given. They can't be using power that they've been given to go against the people who gave them the power. Okay? It is understood that you may have an oversight. Right? This is me giving them grace. I'm giving them grace right here. I understand you could have overlooked this, and that's understandable because I want to live in peace with the people that we elect. I want to live in peace with the people who work for me. I want to be a good boss, okay? That this comprehensive plan trespassed the rights of the people, right? That you serve, because they serve us, but now you have noticed the express will of the people. Now the people have told you don't do it. We told you don't do it. Please take notice that a failure to immediately reject, terminate, remove any and all considerations for the Imagine Rogers County Comprehensive Plan or any plan that alters or intends to alter. I want your motive never to be to change anything about my rights. Don't you ever think about changing my rights, land use, or the enjoyment of the property of the people. If I want to have a cow on my property and that cow's fart contributes to the methane, and the methane melts all the glaciers in all the world, you can't tell me what to do. I want all the methane from all the cows on my property to never be your business. Make sense? That's what we're talking about. By the people will be considered a transgression of the people to the highest degree. If you do this, we are going to be considered that you are now hostile to us. I won't go down that route, but what happens whenever someone is hostile to the rights of the people? Please take notice, the people reserve to themselves the power of the initiative. Now, we need to go back to our handy-dandy hand cam, and we go to initiative. Let's go to initiative. Let me leave that up there. Let me turn this off right here. And I want to look up initiative, because this is where they're going to know that you're serious. This is where they're going to know that you ain't messing around, because you're going to show them in writing that you're going to destroy them. You're going to destroy them, and you're going to tell them that you're going to destroy them. That way, if they do it, you're going to destroy them, and they had full knowledge. Initiative. Where are we at, initiative? I just opened it up. Initiative. The power of the people to propose bills and laws and to enact or reject them at the polls, that's the elections, independent of legislative assembly. So the initiative is the people's power to pass laws and to enact them with independent, that's free from the legislative assembly. I might also say that no court can stop it, no governor can stop it, no commissioner, no one can stop it. Why? Because it's the people's power. So here it is. The people reserve the power of the initiative to themselves, which secures the people's power to make law in the county. And then I go on to say, and just in case they don't believe me, I'm going to say, no judge, commissioner, governor, or legislative body can stop the people's exercise of initiative. I'm telling them, you can't stop this. Okay? Because the people are what? Who are the people? The people are the political sovereigns. All political power is inherent in the people. You can't stop me. You can't stop me. So now I'm saying, please take notice that the people can use the initiative to abolish government. We can do whatever we want with this. How do we know that? Because we have all political power, right? And and hear this is where you need to understand. If Title 19, right? Because this says no effect shall be valid. Where did this power come from? Where did this power come from? This power comes from statute, or Title 19. If it comes from Title 19, where did that come from? It came from the Constitution, right? It came from, the Oklahoma Constitution. Granted, counties, let's go down here to counties. Where are you at, counties? You can go all the way to counties. Article 17, counties. We granted you guys the power to exist. The people literally said, you guys can exist. And now that a county is a corporate fiction, that's what this is, the legislature then goes on and expressly says what you guys are allowed to do. That's what Title 19 is. But Title 19 comes from Section 17, Article 17 of the Oklahoma Constitution. Where does Article 17 of the Oklahoma Constitution come from? Comes from the people. So these guys right here only have a job because the people said that they could. So whenever we say that we can abolish government, it means that you guys at the county level only exist because we allow you to. And we can get rid of you if we want to. Okay? We can revoke powers, which means that planning commission that you're using, to even entertain this nefarious globalist scheme, we can take that away from you. We can take it away. And here's the thing, we can construct law. We can make any law we want to, so long as it's not repugnant to the Constitution. Do you know what that means? It means you can't go against the rights of the people. So as long as the people are going to pass law that doesn't go against their rights, we can pass whatever law we want to. We can make it to where the county commissioners have to stand on their heads in order to conduct the county's business. So if you are going to be in office and you want to go try to conduct business on behalf of the county, you can't conduct business on behalf of the county unless, if we so choose, you stand on your head. Because we want you to really understand that you can turn our world upside down if you use government for the wrong purpose. How can you stop me? Because if someone swears to the Constitution, then they're agreeing to abide by the Constitution. And if the people have the power of initiative, and initiative allows them to make law, if the law is not repugnant to the Constitution, which means it doesn't go against what their rights are, right? Let's just look at that. Let's just look at what repugnancy is. Repugnant, that which is contrary to what is stated before or insensible. A repugnant condition is void. There's nothing repugnant about making your county elected officials having to stand on their heads to perform their duties. Nothing. Because it doesn't go against the rights of the people. If they want the job and they swear to the Constitution, I'm not saying I want to do that. I think that's a dumb idea. We want good servants. We want good governments. We want a good republic. But if they screw around, if they're going to steal your property, if they're going to contract with globalists, if they're going to deprive the people the free enjoyment and the benefit of government, yeah, why not? Why not write a law that says you can't do anything officially unless you stand on your head? Why not? Why not? We already make laws that force people in the military to cut their hair. We already make laws that force people to perform their functions in certain locations under certain conditions. Why not just add a physical requirement? Why not? Why not? If you're going to use my government to turn my world upside down, you cannot use my government to turn my world upside down unless you yourself are upside down when you try to do it. Good luck trying to turn the government upside down whenever you yourself are holding yourself up with your hands. Can't sign nothing in that regard. Just, I'm just trying to show you your power. I'm just trying to show you where you could go with this. Now, by me saying this, the people can take away any and all the county's power we choose, which is true. Then I show them where that's at. Oklahoma Constitution, Article 5, Section 5. Let's just show that real fast. Oklahoma Constitution, Article 5, Section 5. Right there. The powers of initiative and referendum reserved to the people by this Constitution and for the state at large are hereby further reserved to the legal voters of every county and district therein. Isn't that exactly what I just wrote? Isn't that I mean, I left out a lot of it because it kind of tells you how to do it and all that other kind of stuff. But we've got the power. Now, what does that mean, reserved power? in your head, you need to think about the Heisman Trophy. The reserved power is what the people take, and we reserve it from anybody else. So a reserved power can never be legislated on by anybody. Can't happen, because it's a power the people reserve. So if the people have said, we reserve this power, you can't touch it. You can't legislate it. You can't diminish it. You can't take it away. They can distract from it, which is what they've done, but you can't stop us. But now that we know, you can't touch it. You can't stop it. No judge can stop this. No federal executive order can stop this. And from a lawful perspective, no military can stop this. You can't stop the people. Why? All political power is inherent in the people. All right, let's keep going. Let's wrap this thing up. I say Black's Law Dictionary defines initiative, and I showed you this, the power of the people to propose bills and laws to enact or reject them at the polls independent of legislative assembly. And another maxim, he who has a right to give has the right to dispose of the gift. If we give you power, we can take the power away. Please take notice that's the will of the people, that all officers and trustees, that's these guys right here, that's these guys are officers and trustees, that our will is to take action to prevent the maladministration and harms that would take place by enacting destructive plans like Imagine Rogers County Comprehensive Plan. We're telling these guys, kill this thing. Downvote it. Okay? Downvote it. Okay? Please notice that rejecting Imagine Rogers County Comprehensive Plan benefits the people, secures our rights, and demonstrates genius government. I'm telling them, hey, this is how you do a good job. You do a good job by destroying this thing. Destroy it and you do your job good. Failure to reject the comprehensive plan is evidence now. It's now evidence, because now that you have notice, your performance, your behavior, now that you have the knowledge, is going to be the evidence of maladministration. This is wrong administration, which means you're not doing your job. And what are they sworn to do? They swore what? They swore to do their job. They swore to do their job, oath of office. And I even said, the statute you're using even says that you can't go against what the people want. You can't even go against the people's rights. So I'm telling them, you guys can't do this. And if this is the case, failure to do this is maladministration and hostility towards the people's expressed will, because now I've written it. Jaron has now expressed the will of the people. I've petitioned it. I've put it in writing. And it's contrary. There's that law again. Remember, the statute says you can't have anything what? Contrary. Nothing can be contrary. So I'm saying if you do this, you are contrary to what? The fundamental principles of law. You are so far wrong. You are stupid and wrong. Don't do it. Now, here's some things we're going to tighten things up to trap in case they want to get crazy or squirrely. Please take notice that if you disagree or if you believe you have the constitutional power authority to trespass the people's rights, please submit by affidavit sworn under penalty of perjury that evidence to me. Show me under penalty of perjury that you can trespass my rights. They don't have the ability to trespass my rights, so they can't swear under penalty of perjury that they have the power and authority to trespass my rights. And I'm saying within 2 days. Why did I do this? Because they're going to vote on this thing in 5 days. So I want them to put it in the mail, read it, because I hand-delivered it today, put it in the mail, get it to me, and I want to see the evidence. I want to see the evidence that you can trespass my rights. And I put in there, or you agree all statements herein are true. And if they don't do it, then they agree. And if they agree with me, then if they don't do it, it's maladministration and hostility towards the people's expressed will. And it's contrary to the fundamental principles of the law. Now, this last one, this is some important stuff. And I'll explain this, I actually explained this in my common law series, but long story short, the trustees of our government are in contract with the people because they have sworn to uphold the Constitution. The Constitution is a trust indenture. That is a contract. They cannot use the powers of the trust to breach or to go against the benefit of the beneficiaries, the people. So here I am as someone who has all political power, because I'm one of the people, right? All political power is inherent in the people. Because the people have ratified the Constitution and the people are the beneficiaries of the trust, I can now negotiate. I can now renegotiate terms. I can negotiate things that they are now in contract to. They are in contract to me. And by giving them an offer, I'm offering them something of value. The ability to trespass my right is something of offer. It's something of value. I'm giving them something of value right? And I'm saying that it's available right now. You can do that right now. They're now in contract with me, expressly me. They're now in contract specifically with Jaron. And because they're in contract with me, there's all sorts of other things we can do, but now I've reserved the right to arbitrator of my choice. And that brings in some other heavy things that we can talk about later. But there you go. There's your notice to, there's your common law action noticing government officials to lay out what the law is, to stop a globalist plan, to Trojan horse, collectivize rural land, agricultural land, to reclassify people's project or people's property, to bring in ESG, to end public-private partnerships that are repugnant to the Constitution. This is how you express your will. This is how you express your rights. This is how you manage the affairs of government, because we have a republic and not a democracy. So, there you are. And if you're in Rogers County, feel free to use it. If you're in Oklahoma, that's going on in Oklahoma. If you're in another state, you can certainly use the rights that I have expressed, the Oklahoma rights, but use your own state constitutions to do that. If you want more on this, go to... I give a free seminar that does all of this. It's at livelocal.store/common law. Oh shoot, I ran out of space. /common law. livelocal.store/common law. It's how much is this material worth to you? I give it away for free. Put in your email. You get over 12 hours of content of me laying all of this out. I give you maxims. I give you a Black's Law Dictionary. I give you John Locke's Treatise of Government. I give you Bouvier's maxims. I give you all sorts of stuff for free. Because this is for the people. This is how you save your nation. This is how you save your nation in peace. This is how you save your nation in love. And candidly, this is how you glorify Jesus Christ, by advancing the gospel. The common law is the Christian tradition of government. The Christian tradition of government comes from people believing the gospel of Jesus Christ, his great commission, to go make the nations obey, because the truth of his death, his burial, his resurrection is the only salvation from sin. And by believing in Jesus, you are born again, and now you get to live your life for him. So if you get a horrible government that's in the common law, use the common law by God's grace through his wisdom to change your government. And I just showed you how. And if you want to help me or support me, the best way to do that right now is to go to patriotswitch.com/Jaron. It takes the money that you're already spending and it switches it over. It switches it over to an American-made company, American manufacturing, and that supports the work that I do. And by God's grace, I will be doing this throughout the nation moving forward, especially with the machines in elections leading up to 2024. Anyway, I appreciate your time. I already preached the gospel. Happy birthday to Dad who's in heaven. Please take this, share this, use this. It's yours. This is common knowledge for the common people. Until next time, I am Jaron Jackson. I do love America. Do not quit. Go to war.